To learn more about earning college credits with study hall courses, go to gostudyhall.com or click the link in the description. The U.S. Constitution is really old. While the average worldwide constitution since colonial times has only lasted about 19 years before being rewritten and replaced, as of 2023, ours is 235 years old. So this sprightly document has earned some serious bragging rights, and it's probably why Nicolas Cage can't wait to get his hands on it. Part of the reason why it's still around is because there are some crucial early additions back in the late 1700s when it was being approved, and then a few more after the Civil War when the federal government became stronger than ever. But like anything that involves the debate between state versus federal power, how we got here wasn't exactly straightforward, because not everyone was on board with having a strong central government. And in order for our government to be effective, it needed to adapt to the social and political needs of the people. So, bit by bit, court case by court case, our rights became protected from government overreach, at least mostly. Hi, I'm Dave Jorgensen, and this is Study Hall, Power and Politics in U.S. Government. If you've ever practiced religion or attended a protest, then you've seen the Bill of Rights in action. These first 10 amendments, or changes to the Constitution, protect some of our most important civil liberties, like the freedom of religion or speech. The amendments in the Bill of Rights were also vital to the ratification or approval of the Constitution. The new document had to be approved by 9 of the 13 states at the time in order to be official. Getting 9 on board was hard enough, but getting all 13 took 2.5 years, like trying to get your D&D party to make a decision. We're still trying. The main reason it took so long was because during the late 1700s, people were divided between the Federalists and the Anti-federalists. The Federalists can be thought of as being strong advocates for a united states, and they played a big role in shaping the new Constitution. Think James Madison and Alexander Hamilton, the original kind, not the Lin-Manuel Miranda kind. After the failures of the Articles of Confederation, they preferred having a stronger central government to unite the country. And that meant having a constitution that would defend the liberty and independence that had just been fought over in the Revolutionary War. But if you ask the Anti-federalists like Patrick Henry, they'd say the Constitution was strengthening the national government at the expense of the power of the states and the people. The Anti-federalists were wary of having a powerful national government, and so they pretty much opposed ratifying the Constitution. They preferred the weak central government that was outlined in the original Articles of Confederation. In general, the Federalists were more urban, while the Anti-federalists were more rural, but it wasn't a clear geographic divide. So they held constitutional conventions within all 13 states where the two sides debated the future of our country. And you might be starting to see why it took 2.5 years for all the states to reach an agreement. In the end, the Federalists won out and the Constitution was ratified. But this debate had lasting effects because of compromises made along the way, like how we got the Bill of Rights, which Anti-federalists demanded in order to explicitly protect people's individual rights from government overreach. And this compromise also explains why the Bill of Rights didn't immediately apply to state governments. Its primary focus was to limit the power of the centralized federal government, and when it did start to get applied to the states, it wasn't all at once because these factions were still jockeying for power. It took a few Supreme Court cases before federal law was really applied to the states, like in the 1819 McCulloch versus Maryland case, where the Supreme Court unanimously decided that Maryland couldn't tax the national bank, and ultimately that no states can tax anything that's part of the federal government. It was a landmark case, meaning it set a new legal precedent and changed how judges interpret laws from that point on. McCulloch versus Maryland also marked an important application of 2 clauses from the Constitution. It applied the Necessary and Proper Clause, which expands Congress's power beyond what had been explicitly stated in the Constitution. So, in addition to their enumerated or listed powers from within the Constitution itself, Congress also has implied powers, which means they can pass laws they consider to be appropriate and, well, necessary for one of their enumerated powers. The case also applied the Supremacy Clause, which, true to its name, says that federal laws take precedence over state laws when the two are in conflict. Both of these clauses were already part of the Constitution, but in the McCulloch versus Maryland case, the extent and limits of state power were still being fleshed out. But it wasn't until decades after the Civil War that legal restrictions were more universally applied to the states. In a process called selective incorporation, the Supreme Court slowly expanded which Bill of Rights amendments applied to the states as they heard cases over time. And what made that all legal was the 14th Amendment's Due Process Clause from 1868, which promised that the government can't infringe on your life, liberty, or property without a fair legal process. Today, we see selective incorporation at work when the Supreme Court reviews particular laws or government actions. If a law violates a part of the Bill of Rights that's been incorporated, aka already applied to the states, then that law can get struck down for being unconstitutional. Like in the 1925 landmark case of Gitlow versus New York, where the Supreme Court held that the freedom of the press and freedom of speech from the First Amendment also applied to state governments. Benjamin Gitlow, founding member of the Communist Party USA, but not a founding member of my D&D group, was passing out a socialist manifesto that called for the forceful overthrow of the government. And so New York arrested him because it threatened the security of the state. When the case went to the Supreme Court, he defended his actions by saying that no actual harm was caused by his pamphlets, and there wasn't enough evidence to punish his speech alone. But the court ruled in favor of New York and said Gitlow's arrest was justified. And to do this, they had to put boundaries around what speech actually is protected by incorporating or applying the First Amendment to the states. Gitlow versus New York is known as the case that ushered in the modern era of judicial rulings because it established the precedent of incorporating the Bill of Rights on a case-by-case basis. Like in 2010, when the Second Amendment was applied to the states for the first time. The city of Chicago had a handgun ban for decades, so Otis McDonald and other Chicago residents sued the city, saying they needed handguns for self-defense. The Supreme Court sided with McDonald and incorporated the rights to bear arms to the states. These examples show how the U.S. hasn't really settled the debate between state and federal power, and how the court system is the main place where it plays out now that we have a mostly incorporated constitution. But the way constitutional amendments protect us in different contexts is pretty complex. Going back to the First Amendment, it protects our freedom of speech, among other things, but that doesn't mean we're entitled to say whatever we want without repercussions. Hate speech is when someone speaks maliciously, using a prejudiced or harmful stereotype, but it's protected by the Constitution unless it runs afoul of other laws, like true threats or incitements of violence. Meanwhile, fighting words are those that would cause the hearer to react so instantly and so violently that they couldn't control themselves. And defamation is negligently telling certain false statements about someone as if they're fact to a third person. If it's written, it's libel, and if it's spoken, it's slander. Fighting words, defamation, and things like inciting a riot or harassment can be considered exceptions to the First Amendment, but only when their really narrow definitions are met. Meaning, most of the time, things we think of as fitting those definitions would still be protected as free speech. On top of that, we also have speech codes, which are rules that ban speech that would usually be protected but isn't in certain situations. If the Supreme Court hadn't incorporated the First Amendment in the 1920s Gitlow case, speech codes would probably be constitutional. But nowadays, federal courts have limited the use of speech codes across different states, saying that places like universities can't restrict speech that could vaguely offend someone. Instead, speech codes have to clearly and narrowly define what speech is protected and what's prohibited, meaning judicial interpretation can go a long way to affect what can and can't be said in certain settings. Like in 2013, the city of Phoenix passed a law that protected people from being discriminated against based on their sexual orientation by most businesses like banks, restaurants, and, in this example, art studios. Anyone in violation of the law would be fined up to $2,500 or imprisoned up to 6 months. Joanna Duca and Brianna Koski are owners of an Arizona art studio that specializes in calligraphy and custom invitations, and they quickly challenged this law. They didn't support same-sex marriage, which they claimed went against their religious beliefs, and they knew this law would make them complete orders like custom wedding invitations for same-sex couples. So they argued that the anti-discrimination law had actually discriminated against them by infringing upon their First Amendment right to freedom of speech. They invoked something called the compelled speech doctrine, which says the government can't force people, or businesses, to support certain statements or say things they don't want to say. In this case, since all the artwork that went into their custom invitations was fundamentally an expression of their views, Duca and Koski argued that the government couldn't punish them for refusing to create same-sex wedding invitations. Their challenge eventually made it to the Arizona Supreme Court, which ruled 4-3 in their favor. And their victory has been cited in decisions across the country, including the Supreme Court. Contemporary cases like Duca and Koski show how the fight for the protection of civil liberties is ongoing, and how different interpretations of the law can lead to different rules for people living in different states. But some amendments are still unincorporated, which means they haven't been legally applied or even come up in Supreme Court cases. For example, the Third Amendment says that no one can be forced to house soldiers, but that just hasn't been that relevant since the late 1700s, so it hasn't had the chance to be applied by the Supreme Court. Not a single soldier has tried to live in my apartment. There are also amendments that haven't been totally applied at the state level, like part of the Fifth Amendment that says anyone tried in a federal court needs to first be indicted or charged by a grand jury of citizens who come together to decide whether there's enough evidence of a crime. The Supreme Court decided that this wasn't incorporated, but that was way back in the 1880s, and some argue it's due for a second look because it's been 140 years. But still, some states use a preliminary hearing with just a judge to see if there's enough evidence for the person to be charged, and then that judge decides if a case goes on to a criminal trial, rather than a grand jury like in the Constitution. But the defendant still gets a hearing, which shows that at least part of the Fifth Amendment has been applied to the states. And while some parts of the Bill of Rights haven't trickled their way down to the state level yet, that doesn't mean that we're completely unprotected by these amendments, even from state discrimination. But it's kind of weird that the Bill of Rights was only meant to be applied at the federal level. The federal government can't infringe on our civil liberties, but who cares what state governments do, right? And when asking about the times the Bill of Rights doesn't apply, we're actually inviting a more complex conversation about the extent of our civil liberties and the role that the government plays or doesn't play in protecting those rights. And that's a sticky debate that will continue to play out in the courts, just like it has for the last 235 years. If you're enjoying Study Hall Power and Politics in U.S. Government and are interested in taking an online course and earning college credit, go to gostudyhall.com or click on the button to learn more. Thanks for watching. See you next time.